Hey, it's Will of Fed Employees Fight EEO Abuses. I'm just sharing some of the components of my reconsideration request. Again, I shared in some other videos, the reconsideration request is not automatic and it's not a second appeal. What you really want to do is, or the requirement is to demonstrate that the AJ made a clearly erroneous interpretation of material fact of law when they incorrectly applied certain principles or laws. Certain facts, material facts, or laws. And the second component of it is, or you can prove that the agency's policies, practices, and blah, blah, blah will suffer if this practice continues. I've read hundreds of cases. I've never seen anyone fight based on the agency's practices, right? And maybe there's a reason for that. I got to tell you that the whole process is extraordinarily difficult. It's difficult for anybody. If you're a pro se complainant, extraordinarily difficult. But again, the loss ratio is like 98%. So people with lawyers, people without lawyers, they all lose. So why do I keep fighting if we all lose? Because the laws can, if properly interpreted and properly applied, there's room for justice to happen, right? And I definitely understand that as a federal employee, if every employee that opened a claim, and even, I'm not talking about those who frivolous and attack and abuse the system. We're talking about those who legitimately suffered some injury. The first thing we have to do is ensure that it is a Title VII injury. After you do that, and these are I'm finding certain cutoffs. So the first cutoff EEO says, hey, they want to make sure that you have articulated your complaint pursuant to the Title VII laws, rules, and regulations. All right. So that's a way you have to eliminate thousands of petitioners, right? It makes sense. If everybody got justice who got cheated and with a lot of leeway couldn't properly explain it, then the government would be broke. If other people who properly explained it and got justice, the government still would be broke. So I found that the EEOC process actually handicaps or cheats the complainant. If you're pro se, the harder to cheat. If you have a lawyer, well, if you look at every case, go on the EEOC website, look at all those cases, you always see a section says lawyer fees. Your lawyer gets paid regardless. You see they get paid between $270, $370 per hour. So ultimately, you got to ask yourself, who's their master? You may find yourself gone through the process and they want you to settle. And the settlement does not make you whole. Now you understand why. It never worked for you in the first place. So I just want to share. I've shared a couple of the claim numbers. This particular claim doesn't have a number, but I like to share it to you. You might find it interesting. Item C. The AJ made a clearly erroneous interpretation of material fact or law when she incorrectly applied the principles cited in EEO Equal Employment Opportunity Management Directive 29 CFR Part 1614 EEO MD 1T Chapter 110 Chapter 5 at 3 August 5th 2015, comma, Anderson versus Liberty Inc., Celotex Corp versus Catrex, and Matsushita Electric Industry versus Zenith Radio. So you want to make sure you cite the laws that you're claiming or the principles in the laws that you're claiming that they did wrong, right? Cite some court cases and instances of where it's supposed to be applied. And then we got to go on to get specific examples of how it wasn't applied in your case. So I'll continue. While the de novo standard of review requires that the commission examine the record without regard to factual and legal determinations of the previous decision maker, and that EEOC review the documents, statements, and testimony of the record, including any timely and relevant submissions of the party, and issue its decision based on the commission's own assessment of the record and interpretation of the law. I didn't make any of that up. That is simply lifted out directly from the de novo standard and what the law requires. And again, my point is, I'm saying she erroneously interpreted certain facts or law. So I have to be specific. I have to point out the law. You can't leave it up to EEOC to find that law for you, even if they know. Actually, the requirement says, well, skip that. I don't see that in front of my eyes with black and white, so I'm not going to put that out there. Put what out there? During the ROI investigation phase, the ROI investigation is required to cite any violations of law or policy, even if the complainant did not specify it. It's not so crystal clear that that's the case at this phase. But my ROI investigation failed to comply with that. And the AJ ignored that as well. So anyway, I keep going. In the AJ's July 29th, 2020 order entering judgment, the AJ neglected to cite, mention, document, or otherwise rule on claim numbers 3, 4, 6, 7, 8, 10, 11, 14, and 16. How in the world? Oh, by the way, it was an 18 claim complaint. How in the world does the AJ not rule on half of your complaints and still rule against you? That's nuts. But in its March 2nd, 2022 appeal decision, the commission also neglected to cite, mention, document, or otherwise rule on claims numbers 3, 4, 6, 10, 11, 14, and 16. How does both totally ignore your claims? In the March 2nd, 2022 appeal decision, the AJ simply broad strokes and characterizes the entire body of claims, stating, the AJ also determined that the complainant did not establish that the agency was motivated by discriminatory and retaliatory animus, and therefore he failed to establish that any of his claims amounted to a hostile work environment. Listen to that gotcha. That's a gotcha if you ever got one, right? But wait. But the July 29th, 2020 order entering judgment decision also fails to cite, document, and mention claim numbers 3, 4, 6, 10, 11, 14, and 16, and provides no evidence or indication that claims 3, 4, 6, 10, 11, 14, 16 were ever examined, nor examined de novo in the March 2nd, 2022 appeal decision. That is, without regard to factual and legitimate determinations of the previous decision maker. So we're asking, or saying, man, isn't that an incredible coincidence that the first judge failed to rule? The second judge had a requirement to throw out everything the first judge did and rule on the evidence on the record, but yet she failed, or he failed to rule. I say she because all my AJs, I got 4 or 5 more complaints, has been, yes, I've suffered that much abuse and neglect and PPPs and discrimination and reprisals. It's been ongoing. It's been 6 years. Some people will say, how long does it take? It's been 6 years for me. Constant, steady harassment. So it's just coincidence that the first AJ failed to rule on it, then the second one, who's required to rule with new eyes, also failed. Seems to me that's an improper interpretation of material fact, an erroneous interpretation or application. All right, let me continue. By the commission neglecting to comment, cite, document, or rule on the claims, then eliminated or they eliminated or blunted the complainant's ability to prove that this claim was part and parcel of an ongoing discriminatory retaliation and hostile work environment for his prior protected activity. Injustice will result if reconsideration is refused. That is, the movement demonstrates that some harm, legal or at least tangible, such as him not being able to prove his claims of discrimination, hostile work environment, and discriminatory retaliation, due to fragmentation would flow from a denial to reconsideration. See the Cobell case and the Bank Julius. That again is straight out of the books. I didn't make this stuff up. The problem is, even a lot of times, most lawyers don't include this. And I studied, if you're going to do this, even if you have a lawyer, you got to read these court cases. You have to be your lawyer's teammate. You went through it, and you're dependent on them to interpret and translate what you suffered into a legal basis where you can be restored to the position where you were before you were discriminated. So the system is rigged beyond belief, but you have to work as a teammate, and you can't bug them and because they charge you by the hour. So you have to have some degree you have to self-educate. You have to study court cases, study these rules. This almost becomes your obsession. It's more than your job, and it interferes on your home and private life. Well, you say, well, I'm not going to intrude on my private life. But the truth is, we worry, we're stressed, we're afraid, we're intimidated, we're bullied, and it goes into our private life, regardless. So if you want to have a remote shot, you got to put the homework in. You got to do the studying. You got to be a partner with your lawyer. If you're doing it by yourself, some people say to me, well, why are you doing it by yourself, man? Because at this phase of the EEO process, my costs are limited. When I go over into take this to circuit court, then I pay just about everything out of my own pocket. So at this phase, if I can learn how to comply with the EEO process, the rules of how it works, then I can do my discovery. I can learn about the EEO process. I can give it a shot. And again, it's not going for a free ride. This is going for if I feel I really have proven that I've been, if not discriminated against, I've certainly been retaliated, subject to hostile work environment, and harassed. So these things during this phase, going through the EEO process, I can gather all the evidence, the testimony, the artifacts, the depositions that I need to prove my case and get it ready for circuit court. So if I never get justice at this phase, I'm not happy. But based on what I've studied, the 98% failure rate, I'm not surprised. All right, so let me keep going. Even if the appropriate legal standard does not indicate that reconsideration is warranted, the court may nevertheless elect to grant a motion for reconsideration if there are other good reasons for doing so. Again, I didn't make that up. I pulled that right out of the court case, Cobell and FBME Bank versus Nugent. The AJ ignored complainant's overall complaint of harassment and defined his claims in a disjointed manner, leading to fragmentation of the complainant's complaint. In the preamble to 1614 regulations issued on July 12, 1999, the commission advised that fragmentation of EEO complaints was a serious problem in the federal sector, and that harassment, hostile work environment claims are particularly susceptible. So here you see that in that preamble, they stated the problem. And guess what? My judge also was part of the problem. She did the same thing that this preamble said is commonplace. So I'm a victim. I'm not crying grapes. I'm not whining. There's the proof. A lot of us walk away with crying and complaining, and we know we've been done wrong. And we know there's a cheat that happened somewhere in the system. But it's hard to ferret it out and hold them accountable. It's not all the complainant's fault for being unable. The system's actually rigged against it. Why you say that? I've read hundreds of cases, I can tell you. So it says, guess who else says that or verifies that? The Meany versus Department of Treasury case. I cite that. Also, I cite the Drake versus Department of Air Force case and the Equal Employment Opportunity Management Directive for CF 29 CFR Part 14, 1614, EEOC MD 110, Chapter 5 at 3 on August 5th, 2015. So here I've cited court cases where this standard has been recognized as a problem, and I cited the EEOC directive. If you don't put specific evidence, put it with these rules, they won't do it for you. I promise you. They're in the business of eliminating people's claims, not assigning justice. And they really seem to have some resentment towards pro se complainants. And maybe I can understand that too. You're pro se complainant, haven't done any research. My first learning curve, I got bumbled in the head, knocked in the head, stumbling around, and we're pretty emotional about the pain we suffered. We don't articulate it well, and we haven't studied or know the system well enough to present it well. So we just, you think from my AJ's perspective, you got thousands, 10,000 cases that were behind, and here's this guy or woman stumbling, bumbling, can't articulate. She'll call it wasting her time. All right. Okay. I have some understanding. I'll continue on. A claim refers to assertion of unlawful employment practice for which, if proven, there is a remedy under the federal equal employment statutes. Fragmentation often results from a failure to distinguish between the claim and the complainant is rising and the evidence or factual information she is offering in support of that claim. When each piece of factual evidence, usually consisting of a single incident, is identified as a separate and distinct legal claim, it ignores the complainant's real underlying issue of a pattern of ongoing discrimination. That's exactly what I'm saying. For complainants, fragmented processing can compromise their ability to present an integrated and coherent claim. That's exactly what the judge did to me. She compromised my ability to present an integrated and coherent claim. The fragmentation of the EEO claims must be prevented at all levels of the complaint process, i.e., complainant's complaint and its attachments unmistakably raise a claim that he was harassed by supervisors S1, S2, I have to modify that, and S3 for me, and subjected to a hostile work environment. The complainant, I'll just put the supervisors, by management and subjected to a hostile work environment. The complainant requests that the commission reverse or overturn the AJ's ruling on 3, 4, 6, 10, 11, 14, and 16, and then review them de novo to determine if the complainant should be awarded summary judgment for them all or subset of them, and award compensatory damages. You see, so now I'm saying, hey, you never ruled on it. I'd like for you to rule on it with the evidence that's in the record. Injustice with result of reconsideration is refused. Seems like I've done that already. Oh, I have. All right, so I pull that out. And glad you gave me the opportunity to sit here and read this over with you. I see that I repeated that whole section about injustice, so I'm going to pull it out. My whole list of complaints is already long enough. I got 18 claims in this complaint. Judges really don't have a whole lot of time to mull over this stuff, so being redundant just doesn't help. Hey, I have a few more videos, and I'll be putting a few more on. You can find us over on our Facebook group at Fed Employees Fight EEO Abuse. And you're seeing this over here on YouTube. I won't create a channel. I've actually been inspired by another person that went in front of us and did this very thing, put videos out. The more that we talk amongst each other, the more that we share notes, the more that we help each other through the emotional part and pain and suffering in this process, the better we can make our federal work environment for everyone. Thanks again. I'm Will.